tonight. Good evening. I'm sorry, this is a continuation of 11062. Some internet issues, but we'll continue. So I was discussing the issue of plagiarism and referencing. Please ensure that you're on top of those topics in a general sense. If in doubt, reference your material. Please try to avoid plagiarism and improper collusion. So you can collaborate, but not collude in an inappropriate sense. I hope that makes sense to you. Now, I mentioned that tonight's an important issue, but before we embark on the content specific for this subject, just a reminder about statutory interpretation. Most of you have covered statutory interpretation, so I will be brief. Some of you may have even done that with me as the unit coordinator. But you'll recall that at common law, there's three different approaches: the literal approach, the contextual approach, the purposive approach, and there's a number of common law presumptions. These days, we tend to look at the purposive approach. Do consider the Acts Interpretation Acts of both Commonwealth and State. In that regard, have a case or two up your sleeve. Project Blue Sky, for example, Mills and Meeking is another good one, to identify particular areas of statutory interpretation. Always good to enhance any argument that you might put forward by reference to statutory interpretation principles or some of the important primary and secondary sources of law. For example, second reading speeches. We talked about that last week. Just remember that there are a few common law presumptions that are still important, like words have their current meaning. There was a case of Jones and Commonwealth, 1965, 112 CLR 206, that dealt with that issue in the context of, the transition from the legislative power of the Commonwealth under the Constitution to make laws in relation to postal, telegraphic, telephonic, and other like services. Because in 1965, we were going beyond the technology that was contemplated at the time the Constitution was created. So the general meaning is those words have their current meaning. And of course, even now, we're well beyond what the technology was in the 60s, of course. Another one is words have their technical meaning. And you'll notice in law, as you study through the degree, that there are some words that are used in common usage, something like consideration, but it has a particular legal meaning, and words generally should be interpreted subject to their technical, if you like, legal meaning, rather than the meaning in a general sense. Other examples would be frustration. This has a particular legal meaning, particularly in the context of contract law, and provocation has a particular meaning, particularly in the context of criminal law. And another thing is things not included are generally excluded. That can be something that works against the first one that I mentioned. So sometimes you need to consider these principles, but where in doubt, go back to the purposive test and think about things like Section 14A of the Acts Interpretation Act. Think about Project Blue Sky. And remember, of course, if you're looking at a statute, the way I think you should do it is look at it as a whole at the start. That doesn't mean reading it all. It means getting a feel for it. And the best way of doing that is to look at the overall structure, look at the various chapters, the parts, the headings, get a feel for how the Act works, and then look at the objects and the purpose provisions, and then you're well on the way. Do that before you start to read a particular section of an Act, because you'll then better understand that section within context, and you'll better understand the purpose of that section. So that's why I urge you to look at the Act as a whole before you dive into the detail. In terms of the purposive approach, I've mentioned Section 14A. I've mentioned Mills and Meeking. That's a good case that you link with Section 14A. And Section 15AA of the Acts Interpretation Act, Commonwealth, also refers to the underlying object of the Act as something which is preferred to any other interpretation. So if you're looking at something like the ACL and you've got any doubts as to how this section should be interpreted or applied, go back to the Acts Interpretation Act, go back to things like Mills and Meeking to properly interpret the statute. So read it and the statutory provisions literally, but do so within the context of the provision and ultimately determine the purpose of the provision, and then you're well on the way to properly answering legal problems that are based around that statutory provision. I know that's a flying overview of statutory interpretation, but it is important, and the purpose of that is to remind you that it has an ongoing importance. It's not just something you learn in statutory interpretation and lock away. Continue to use it in this and other units as you proceed through your study. Right. Any issues around that? Now, remember, of course, that there may be some key words, phrases that are defined. Always look for definitions, but I'm sure you do that. Now, I'm leading into how this might be even more relevant for contract law, because we have a whole area of law which deals with statutory interpretation. We also have an area of law that deals with contractual interpretation. So when you're looking at a contract, there are special ways to interpret it consistent with our law. One of those, and I've alluded to this and mentioned it a few times, is that generally speaking, when you're looking to interpret the terms of a contract, you do so by adopting an objective approach. And that may be a different conclusion to the subjective approach. You're looking at how each of the terms of the contract might be considered and interpreted from the perspective of a reasonable person looking at it, rather than necessarily rigidly applying the interpretation as a result of what an individual may have thought it to mean. So the test generally is, if you're looking at something in a contract, you're not sure what it means, ask yourself, well, what would a reasonable person think this term means? So the subjective intention is not strictly taken into consideration. There's another very important rule of contractual interpretation. It's the parole evidence rule. I suspect you dealt with this in Contract A. Am I correct in that assumption? Keep it in mind, because if a court is called upon to interpret the terms of a written contract rather than an oral contract, the court will generally consider only the written terms in relation to the context or that which was contemporaneous or a verbal exchange. So there's the parole evidence rule that you need to consider. And it only applies in written contracts in certain circumstances. Now, there are some exceptions. Brush up on that, keep it in mind, and be prepared to apply it in any answer that you come to. Another contractual interpretation that we've already considered at various times throughout the unit is the whole concept of uncertainty. And you'll recall that I've said at various times, courts will try to fill gaps in a contract, but there are limits to this. And courts will only imply a term into a contract if it's satisfied of all of these things: that it's reasonable and fair to do so, that it's necessary to do so, that it almost goes without saying. Yes, that it's not there, but it goes without saying that that should be included. That it can be clearly expressed and it's consistent with the expressed terms within a contract. Courts will adopt the objective test in introducing or implying terms into a contract. Now, you might say, John, I don't understand. You've just mentioned the parole evidence rule, and now you're talking about courts implying terms into a contract. And unfortunately, law is a bit like that. And you can either adopt one of two approaches. You can either say, oh, this is silly, and I can't get my head around it, and I can't find the answer that I need. Or you can consider it as liberating and think, this is great. If I'm presented with a legal problem, I can use these principles as a way of enhancing the argument that I wish to promote, and not necessarily advance other arguments or principles if it doesn't help me. Now, you've still got the overriding paramount duty to the court, so you can't mislead, etc. But you can certainly approach it in different ways. And you know, it's a strange dynamic, but sometimes, for example, in say the magistrate's court, duty lawyers might be in say domestic violence matters acting for some people that are the aggrieved, and then some people that are the respondents to a domestic violence order. And when they're standing on one side of the bar table, they're arguing to the best of their ability in relation to one area. Then they literally move to the other side of the bar table and advance what seems to be on its face almost the exact opposite, because they're now acting for a different client. And that's the nature of law. So you're there to argue for the benefit of your client, but do so within the legal constraints, but perhaps use some of these techniques to advance the argument. And I hope that helps you when it comes to formulating your response to the second assessment. The other thing is just bear in mind, without necessarily having to go into this in an assessment for Contract B, remember the basics that you learned in Introduction to Contract Law: offer, acceptance, communication, consideration, intention to enter into legal relationships. Just keep an eye out for that. Make sure that you know the difference between offer and invitation to treat. Keep an eye out for that. Think about the difference between a contract, which must include consideration, and a deed, which does not require consideration to be lawful. Even though they look very similar, there are distinct legal differences between those two documents. And then remember, of course, as we've discussed already, the impact of legislation and case law into contract law. It might be through statutory interpretation, it might be through statutory obligations, it might be something very broad like the ACL. I've covered a lot already. I hope that wasn't too much to take in, but it was more a refresher. Now, are there any questions in relation to any of those things that I've covered very quickly now? Question, are we talking about the exam or the assessment too? Both. All of these things apply to both. Human rights, says Bridget, reminding me, is an important area. Well, I think that was an earlier discussion, Bridget, maybe when I wasn't there, but it is always important to consider. I just, yes, yeah. he's been abducted. All right, thank you. So, but do think about human rights. That's a really good point to raise generally. No questions? All good? All right. And I mentioned having something of a toolkit that you use and you refer to, and it's important that you have that for terms that you come across and principles you come across, and have some legislation, some case law to back up these arguments almost at your fingertips. Now, I don't know if I've mentioned Section 8 of the Civil Proceedings Act, Queensland. Have I mentioned that previously? I'm just going to, it's a very short sentence. I'm going to read it to you, and I'm just going to ask if you're putting your skills together in such a way that you can understand this very simple, apparently simple section from, which is Section 8 of the Civil Proceedings Act 2011, Queensland. If you're on access to a computer, feel free to have a look at it. But here it is. Section 8 is headed Equitable Damages. First thing, if you have to argue something, does the heading count? Are you allowed to use the heading in a statutory interpretation principle? Don't answer now, but that's got to be in your toolkit. You've got to know that. Now, here's what the section says. If a court has jurisdiction to hear an application for an injunction or specific performance, the court may award damages as well as or instead of an injunction or specific performance. On the face of it, simple section, but break it down. If you're trying to answer a question around that, or you're trying to use that section to advance an argument that you're putting forward, you need to know, firstly, what they mean by if a court. Is it every court? Is it a mental health review tribunal? Is that a court? Can you use this section there? Clearly not. Is the magistrate's court a court that has equitable jurisdiction? Can you use it there? Etc. What do we mean by the term jurisdiction? It means the authority to deal with the matter. So if a court has the authority to deal with the matter, to hear an application, then here are some rules. So the threshold questions you need to start to get your head around is, well, that tells me that some courts have jurisdiction to do certain things, other courts don't. So when you're reading a case, when you're looking at some of the secondary material, keep your wits about you and ask yourself questions constantly. I wonder why this court dealt with this matter. I'm assuming it did have jurisdiction, otherwise you'd think the court wouldn't deal with it. But given the monetary value, why wasn't it dealt with in some other court? Things like that. So that's what I'm asking you to be concerned about and careful of. An application, I guess, is pretty straightforward, but you would have noted that sometimes there are different words used regarding initiating an action. And you'll see that in civil procedure, but sometimes it's an application, sometimes a claim, things of that nature. So there are different ways that a court action can be initiated, is really the point that I'm making there. So keep on guard for that. Injunction or specific performance, well, we know what they are, don't we? They're equitable remedies. And so you're essentially saying, if a court has jurisdiction to deal with this application for two very specific and important equitable remedies, then the court may award damages, not common law damages, but equitable damages. Hence we go back to the heading. Again, I know that's a lot of work, but just keep it in mind, because sometimes people say, you know, in response to a question, what would be your advice to a client? And people say, they should seek an injunction. Well, if you look at Section 8, we can actually go a lot more than that, can't we? In terms of answering the question, we could say, we could make an application seeking injunction that says that you know that it's an application rather than say a claim. And if you're really good, you could identify the appropriate court or courts that would have jurisdiction to hear the matter. And if you're really good, you would then say, well, seek an injunction, and in addition, or perhaps instead of that, in the alternative, seek damages, that is equitable damages. So you can see that when you look at a section, when you look at a case, it helps you to build in your mind the various options to extend a very simple argument into a much more tailored, detailed, and correct answer. Do you understand what I'm getting at? All good? All right. So you can be very inventive in this, and we need you to continue to develop your active reading as well as your active listening skills. Now let's deal with week 7 material. As I mentioned earlier, it's very important. Textbook and the casebook, both chapters 20. And we're dealing now with discharge of a contract as a result of termination or breach or repudiation. I'll rephrase that. Discharge by termination as a result of breach / repudiation. So we need to understand what these terms mean. And if you think about it, most of the cases that you read about in contract law will be in relation to alleged breaches of a contract. That's what most of these cases are about. And this area, this week, deals with that central issue relating to breaches of contract. That's why it's so important. And that's why this is the sort of week where examiners look to create problem questions that might exist in an examination. That might be an exam hit. You need to understand the terms. Now, one term is anticipatory breach. We know that means where a breach hasn't actually occurred, but the circumstances make it clear that it's inevitable that it will occur. So even before the breach occurs, a party may take action based on an argument around anticipatory breach. But you need to know the extent to which you can do that, and when you might do that, and some of the pitfalls if you get it wrong. And this is a big part of this area. There are pitfalls. On the one hand, you need to act decisively. You need to identify something and make a call and make it clear. But on the other hand, if you get it wrong, your opponent may call you out on that and say, you're purporting to do something. I'm saying that you're wrong in purporting to do that. I'm now calling you out for your breach of contract in wrongly alleging that I'm in breach. Does that make sense? It becomes a bit circular. And so this concept of repudiation is something that can, in many cases, be used as an argument by both sides, both coming to the court to say they repudiated the contract, we've terminated the contract lawfully. The court needs to determine who has repudiated and who has terminated, who has taken the legal action and who has acted improperly. And sometimes you don't get much time in practice to think about this. You've got to make your call and work on it. Now, a word that you see a lot in this area of practice is repudiation. And it means where there's repudiation of a contract, a party is or states they are not ready, willing, and able to complete their obligations under the contract. Either that or it's implied. Now, in conveyancing, it's very common for one party, in attempting to be in a position to allege the other has repudiated, to make it very clear, I'm ready, willing, and able to settle. I'm now calling on you to settle. And if you're not, I reserve my rights. If the other side doesn't settle when called upon to do so, then the first party, having said, I'm ready, willing, and able to settle, is now able to say, you've repudiated the contract, you failed to perform, I was ready, therefore I'm entitled to terminate based on your repudiation. Too many words? Following me? Okay. And when it comes to these sorts of decisions, there's a basic dichotomy in the terms of the contract that you need to consider. And the term of the contract that goes directly to the substance of the contract, such that non-performance can be considered a substantial failure to perform the contract at all, is a condition. If a particular provision is regarded as a condition and the other side breached that condition, it's a little easier for the other side to say, you've repudiated, I'm terminating, you've breached a condition. Now, on the other side of the coin, if it's a warranty, it's a term which, if breached, entitles the innocent party to damages, but it doesn't entitle the innocent party to terminate the contract. So what happens if party A breaches the contract, but by it breaches a warranty, party B calls them on it, you're in breach of the contract, that's a repudiation, I'm now terminating. Party A says, you didn't have the right to do that. Even if I concede that I breached the contract, I breached a warranty that may have given you the right to damages, certainly didn't give you the right to terminate the contract. Because you've purported to do that, you've repudiated the contract, now I'm terminating the contract. So you can see that the wrongdoer can twist it onto the innocent party, and the wrongdoer ends up terminating the contract because of the repudiation of the innocent party. Am I playing with your head too much here, or is it making sense? And it really comes down to this initial call. Am I dealing with a condition or am I a warranty? But wait, it gets even more interesting, because in between the two, we have intermediate terms. And an intermediate term is a term of a contract when breached, sometimes acts like a condition, and sometimes acts like a warranty, and that depends on the gravity of the breach. And that's an area where examiners like to ask questions. And if you embrace the comments I made earlier, that gives you an opportunity to say, you beauty, there's arguments both ways here. I'm going to pick a side and I'm going to go and run with that. I may not be wrong. I may not be right. It might be not the answer that the examiner thinks is the correct way to go, but I can still get a 7, provided I run the argument well. All right, can I ask you this, and I'll get you to answer with a yes or a no. Do you feel fairly confident that you at least understand the distinction between conditions, warranties, and intermediate terms? Just a yes or no at this stage. The votes are coming in. Well then, very slow votes. We're getting a couple now. Yes, we're all saying yes. Good, that's the right answer. If you're not, the request I have of you is brush up on this, but even if you're confident with it, I'd ask that you have something catalogued in your toolkit, whatever the form that might take, to identify a definition. It might be the one that's in the study guide, or it may be something that you draw from another source for these things. Have an example or two, and have some arguments, maybe some quotes from court cases or from legislation that will assist you in arguments, so that if you go into a problem-solving question in an exam type context and you say, I believe this is a condition, then you might have some arguments to support that contention. So generally, it's something for a condition goes directly to the substance of the contract. If someone doesn't perform, then it's a substantial failure to perform, but it's not always obvious. A good case that highlights the ambiguity in that area is Luna Park and tramways advertising. You've probably seen that case. Luna Park contracted to have its attractions advertised on trams. Tramways guaranteed it'd be on the tram tracks for at least 8 hours a day. The tramways subsequently tried to argue that that meant an average of 8 hours per day, but it lost. The period per day was such an important part of the contract that without it, there may have been, the court said, no contract at all. So the key fact here is that a breach of a condition is one that gives rise to the innocent party to terminate the contract. As I said, the opposite applies to warranties. It might still be important, even especially important, but it really is not possible to say that if the warranty is breached, then there may as well not be any contract at all. So have some definitions. Associated Newspaper and Banks is a good example in that regard. So we've got conditions, we've got warranties. Now we get to the grey area of intermediate terms. A couple of key cases here that you need to get your head around and be ready to argue around. I'll just take a straw poll. Does anyone want to give me some idea of a key case that you might think is important if you're running an argument one way or the other about intermediate terms? If you don't know, that's fine. But if you do, just use the chat facility, let me know, or even unmute your microphone. Zero votes so far. That's all right. So we'll need to look at this, and we'll deal with a couple of examples. Okay, so let's have a look at some examples. The two that I want to highlight for you tonight. Firstly, Hong Kong Fur Shipping Co. against Kawasaki Kizan Keisha. It's an English decision. It's 1962 to QB, Queen's Bench, 26. Now, the facts are this. A vessel was chartered, said to be in seaworthy condition, The vessel was in seaworthy condition for 80% of a voyage, but it was unseaworthy for the other 20. It resulted in interruptions to the charter, and the court found that seaworthiness was certainly an obligation under the contract, and it certainly could have acted like a condition, making the contract not worth having. But the unseaworthy portion of the hire was relatively small. Well, it's a brave call when it was 20%, but that's what the court found. And the consequences were insufficiently significant in that case. So even though on its face it might look like an absolute condition of the contract, the court held that the seaworthiness of the vehicle was regarded as an intermediate term, and therefore as an intermediate term it could be treated like either a condition or a warranty, depending on the precise nature of the breach. Any questions about that case? Or generally? All good? Faraz, no questions? Comments? All right. So the key point there is a breach of a condition or intermediate term, depending on its significance, would entitle an innocent party to terminate. If a clause is essential, then it's a condition, and a breach of a warranty only generally allows an innocent party to claim damages. Now, there is the issue of termination of a contract at common law, and we know that if it's termination based on breach of an essential term, that's possible. A non-essential term or repudiation of the contract is also possible. But essential terms are distinguished from warranties. That's a key issue. Now, if a party commits a breach of a non-essential term, if you like an intermediate term, as indicated, it may give rise for the other party to terminate the contract at common law. And here's the second leading case that I want you to be aware of in this area. It's Kumpatu, Local Aboriginal Land Council, and Sandpine, Pty Ltd. I've referred to this case previously. Kumpatu is KOOMPAHTOO, Local Aboriginal Land Council, and Sandpine, SANPINE, Pty Ltd. It's 2007 233 CLR 115. To allow termination on the basis of breach of a non-essential term, the court must be satisfied that this was an obligation of basic importance to constitute an essential obligation justifying breach. So when it comes to repudiation, we're saying that it goes beyond breaches of essential terms, and it may go beyond serious breaches of non-essential terms. Anticipatory breach is an area that may be relevant in this area as well, because generally repudiation is a combination of all of these things, and a party is said to repudiate if it exhibits an unwillingness or inability to render substantial performance of the contract. Now that could be anticipatory, or it could have been past actions. But again, a good case to refer to in this area is Kumpatu. All good so far? I know it's a lot. So essentially we've been talking about two different types of breaches tonight. Leaving aside the extent of the breach and the type of breach, there are two basic types. Number one is a failure to perform. Number two is a breach in anticipation, anticipatory breach. So a failure to perform occurs if one party, without lawful excuse, fails to discharge a contractual obligation against the anticipatory breach, which happens prior to the time appointed for performance, and one party is unable, expresses their inability to perform. Now, the reason that this is all important to make these decisions is that it comes back to this fundamental issue that I mentioned, is if you're going to terminate a contract, what is your justification for doing so? And generally speaking, a termination is justified if the words or the conduct of the other party gives rise to a repudiation of an obligation, or if the other party indicates that they're wholly and finally disabled from performing the contract. It's pretty easy to determine if a party is just not going to perform the contract at all. It's much more difficult if the words or the conduct give rise to repudiation. So we need to get these terms right, have some examples, and think about it. So, failure to perform. Failure to perform can occur when the time for performance has expired, but anticipatory breach precedes the time of performance. Now, failure to perform is the simplest type of breach. One party simply fails to perform. But the question then is, that's all very well, but is the obligation a conditional warranty or intermediate term? So you need to just plot out in your own mind, when do I raise these arguments? It's almost like developing a little flowchart for yourself, adding in cases where relevant. If a party not performed is a warranty, or it's an intermediate term acting like a warranty, the parties continue to be bound by the contract, or the innocent party can seek damages. But if the term is a condition that's not breached, or it's an intermediate term acting like a condition, then the innocent party may terminate the contract immediately, and the innocent party may seek damages for the harm suffered. It comes back to Section 8, where you can argue multiple arguments. So in Luna Park, the park could immediately regard the contract as terminated and cease making any payments they would have otherwise been made under the lease. And you can see where this means that, coming back to that central question, you've got to make a call. You've got to say, I regard what you've done as a breach. I regard it as a breach of a condition, or I regard it as a breach of an intermediate term acting like a condition. That entitles me to argue that you have repudiated. Given that you've repudiated, I'm now lawfully entitled to terminate. Having terminated, I'm now lawfully entitled to seek equitable damages, for example. So you can see the logic, but it depends on that threshold question, whether go one way or the other. So it's critically important to determine whether the breach term is a condition or a warranty. In the context of answering a problem around this area, it won't be good enough to say, Party A has breached, therefore you should seek an injunction. That's just snippets of an answer. It's not a logical flow of a legal answer that leads to that conclusion as to what you can do. But many students make the fault of simply saying, there's been a breach, seek an injunction. Or been a breach, seek damages. That's okay at a very superficial level, but the purpose of tonight is to take you to a better level, a more advanced level, like I was talking about with Section 8, for example. All good? So when you're considering whether a breach term is a condition or a warranty, it's really referred to as the test of essentiality. Was the term that was breached essential to the performance of the contract? If the answer is yes, then the other party generally has the right to terminate. But if the answer is no, the other party is generally only entitled to damages. So you've got to make that call. And the right to terminate for breach does arise at common law, but there might be some express terms in the contract. So it comes back to that first comment that I made, that first comments that I was making about contractual interpretation. That's why it's really important you look at the terms of the contract as well. And there are some restrictions on the ability to terminate, and there are some correct and incorrect ways of terminating and the procedures that you might adopt. I mentioned, for example, in conveyancing, that one party might work themselves towards a position where they can lawfully terminate by ensuring that they are, for example, ready, willing and able. They've made that known to the other side. They can demonstrate it. Having established the higher ground for themselves, they're then in a position to attack the other side. I hope that makes sense. So a key thought here is that the right to elect to terminate is something that you should do after very serious thought. In practice, it's a real minefield. If the terminating party gets it wrong, doesn't follow the right procedures, doesn't adopt the right reasoning, then in turn, the other side might allege that they have repudiated the contract and allowing the wrongdoing party, as I mentioned earlier, to terminate the contract. So one party may terminate for a purported breach. The other party may treat this conduct itself as a repudiation. They may purport to terminate. You've now got both parties purporting to terminate, and the first party may argue that the second purported termination itself was a repudiation. That's why I say it becomes circular. Think that through. Try and get your head around it so that you're ready to answer a problem question that might, that's a hint, be on this area in the exam. Okay. It's tough tonight. I know it's important, but it's tough.
Stressful.
Stressful. It's meant to be a G up. It's not meant to stress you out. It's meant to invigorate you and make you feel, oh, this is great. I've got lots of choices that I can make.
It is actually better to hear you explain it rather than just the reading. Because I've done the reading, and to hear you go through it and explain it like that, it does make more sense.
Yeah, it's sort of more a practical how it works in reality. So thank you. I appreciate that. Now, proving failure to perform is difficult, but there are three main types: non-performance, defective performance, or late performance. Non-performance arises where there's been an attempt to perform, but the performance was quite different to that which was required under the contract. I mean, for example, if the seller sends beans instead of the contract requiring delivery of peas, well, that's just non-performance, isn't it? Defective performance is where it's not of the quality or the quantity required under the contract. It may or may not be fit for purpose. If you're thinking about these areas, you've then got to start thinking about the ACL, because a lot of these issues do crop up in the statute as well. And then there's late performance. So it might be that everything's right except the time. In contract for conveyancing, time is usually specifically stated of being of the essence. So a buyer of property may turn up with the check and have done everything right, but be 1 day late. By that stage, potentially, too bad, too sad. So sad. The other side may have treated their failure to settle and perform on time as repudiation, may have purported to terminate the contract, and may have now made a claim for the deposit having paid by the buyer to be forfeited to them, and the buyer stands there holding their check 1 day late, now without a property, without the deposit, it's gone, and thinking, well, have I got some right to apply to a court to turn this around? But if time is of the essence, if the first party has done everything right and set themselves up to validly terminate, the party that was late may have been wrong. So this is the distinction between, now I'm talking about late performance and that issue of time is of the essence. So you can see that central to this whole question of determining whether there's been an actionable breach or not is this doctrine of repudiation. And when a party enters a contract, the other party can assume that both parties are ready, willing and able to perform their obligations. But what if a party is ready, willing and able, but then for some reason later is no longer ready, willing and able? And that can happen for a whole range of reasons. The innocent party needn't sit back and watch and wait for things to go completely pear-shaped, which means that anticipatory breach has a part to play in this as well.
Can
So
I
the
ask you a
doctrine
question,
of,
John?
yes, Bridget?
I actually had a conversation with someone about something like this yesterday. Dan and Steph, in Harvey Bay. They ordered that big brand new wood fire pizza oven. And of course, time is of the essence. They're opening a restaurant. And it was
I know
late.
exactly what you're talking about, which one it
Yeah,
is.
but it was late because it was coming from Sydney. And then when it came up, it was damaged. But it was late because of COVID, not necessarily because of anything they had done wrong. So what happens in a situation like that?
Well, I won't provide any specific legal advice on that issue, but coming from Harvey Bay, I've got a fair idea of what it is that you're talking about. But this is where, and I'll just answer very generally, it comes back to that issue of you're presented with a set of facts. Nobody tells you whether this is a condition or a warranty or an intermediate term. Nobody tells you, and you've just got to make a call. And, if you say, well, the other side have breached, I'm now terminating, they may have a different view, etc. So it becomes that circular thing. So I'm sorry I'm not answering the question directly, but I'm not sure it would be appropriate for me to do so. I hope that makes sense. All right, but the doctrine of repudiation does allow you to look at the actions of the other side, and the general rule is make sure you're ready, willing and able, but if it's apparent the other side are not ready,